my candidate has a criminal record, now what? Our speaker today is Jason Morris. He's a veteran screening and risk management professional. Jason Morris founded Employee Screen IQ in 1999 and acts as the company's chief operating officer and president. Morris is a frequent speaker delivering captivating interactive discussions on background checks, global screening, recruitment, and staffing. He educates audiences in best practice initiatives as they relate to organizational employment screening programs. Morris has been quoted in numerous business and industry publications, including the Wall Street Journal, MSNBC.com, USA Today, New York Times, among others. He is also a licensed private investigator in the states of Ohio, Illinois, New Jersey, Texas, Arizona, and Nevada. So let's welcome Jason.
Thank you. Well, somebody used the word captivating in that, and that wasn't me, so I hope I keep you guys up. It's kind of early. Everybody drink their coffee. Put away the tomatoes. So my presentation is titled "My Candidate's a Criminal Record, Now What?" But there's about 3 or 4 presentations that I've spent, last several years traveling the country and speaking at different SHRM conferences about. And whereas the criminal record part is the sexy part of what we do, there's some other things that I kind of threw in here. Some towards the end. I want to make sure we can have time to get to them. We're going to talk a little bit about social media. We're going to talk a little bit about diploma mills, because we're seeing a lot of those right now. And we're going to focus, as we're talking about the criminal record aspect of what we do, a bit on the EEOC criminal record guidance that came out in 2012 that still some people just don't really know about. A little bit about my speaking style. I move around a lot. I go on little rants, and I tend to confuse people. So if I do confuse you, and I'm off topic a little bit, just throw your hands up and say, what are you talking about right now? Because I do tend to do that. So something else, don't worry about taking notes today. If you go ahead and leave me your business card on the table, I will send you not only a copy of the presentation, but we're going to talk a little bit about some white papers that we've published and some studies we've done, and we're going to talk a lot about some legal topics that have come up in the last couple of years. I'm going to send that all to you. You'll get that in the next few days when I get back to the office, and you'll get a nice email from me. I promise we will not solicit you too much. A little bit more about me. My name is Jason Morris. You can see my resume out here. It's a little bit blurry. After receiving my degree in criminal justice studies from Kent State University, any Kent Staters in here? No? I went on to receive my MBA and my PhD from Gordon University. When you do ask questions during the presentation, and I do like to make this interactive, so just raise your hand if you have a question at any point. I prefer that you address me as Dr. Morris. I did work very hard on my degree. I worked so hard on it that I bought it online for $295 from a diploma mill in Japan. In receiving my degree, there's me, sorry. In receiving my degree from Kent State, obviously you can see it's a nice legal degree. I really did receive that with a nice raised seal and real signatures on there. My degree from Gordon University also has a raised seal. It also has a fresh signature, wet signature on there. Came on nice paper. There's my PhD. My in-laws, my wife's family, they're all PhDs and professors, and they went to school till they're 95 years old. And they love the fact that I'm a PhD now, and I bought mine online pretty quickly. I like to rub it in their faces as much as I can. So along with the service in purchasing my degree for $295, they also provided me with an email address and a website and a phone number that any of you nice HR folks can call and verify my degree. There's a call center waiting. They'll answer the phone saying Gordon University. This is our registrar's office, and you can say, hey, did Jason Morris graduate from the university? And they'll say yes. I also paid an extra $100 for transcripts, so if you want to get a copy of my transcripts, they will fax those to you. I really did well. I mean, I really, my grades were awesome. Same thing with my PhD here. So as you can see, when you're doing background checks, it's pretty much an art. The criminal records are fairly easy to get. If you go to the county boards, we'll talk about how that process works in a few minutes. But the verification of education and employment, sometimes it's very easy to fool you if you don't know what you're doing. Everybody's seen the Seinfeld episode with Mandalay Industries when George wants to get a job and gives him Jerry's phone number, and Jerry's supposed to answer the phone at Mandalay Industries. It's very easy to trick people into thinking that somebody actually works somewhere. Same thing with these diplomas. It used to be when we first started in the business that all we really had to do was verify that the college or university was accredited. Well, as we've gotten smarter as screeners, the criminals have gotten smarter as well. So what did they do? They created fake accreditation bodies. So now not only do we have to verify that somebody comes from a real university, but we also have to verify that the accreditation body is an actual accreditation body that's justified by the U.S. government. So again, we see these every single day. They're very easy to catch, but you want to make sure that your screening company is cross-referencing your employees versus against these known diploma mill lists. So when we're doing it, we have known diploma mill lists, we have white lists and black lists that are known. We've got a hodgepodge of industry information that we share with each other. And then we also have some government lists that we look at as well. We also make sure that when an applicant provides us with a phone number or a way to get to the registrar, that we don't just take that as gospel. We actually go and do our own research to make sure that we're calling the right place. Same thing when somebody says they work for Microsoft and provides us with a name and phone number. We're not going to take that. We're going to actually go online or Google it or something else and make sure that we're actually calling the right place, because it's very easy to trick. You look at what a resume is. A resume is nothing but a sales tool. It's an applicant telling you exactly what you want to hear so they can get the job that you want to give them. They're not going to put negative things on there, and if they're truly desperate, they're going to throw out 100 applications with false information on there so somebody gets tricked into giving them a job. People have to work, and that's the song and dance that they follow when they're doing this. So, and another thing is I hate reading off of slides, but there's going to be some legal stuff that we're going to talk about, especially when we're talking about the EEOC. I want to make sure I get it right when we're talking about best practices. So you will see me taking a peek. Every day, as screening companies and HR professionals, we get our Google alerts or we go online and we see lawsuits out there, things that affect us as HR professionals and screening companies. There's tons of lawsuits right now. We are seeing plaintiffs' counsels teach classes on how to sue employers and how to sue screening companies for very technical violations of the FCRA. Some of them are quite egregious, like this one with Pepsi. Pepsi was basically, and this is an older suit, they were basically gathering their background check information from their supplier, and without even looking at it, they had a pile of hits, a pile of clears, the pile of hits just kind of went to a different part of the table, and they weren't hired. The U.S. government, the EEOC, FTC, they want you to really look at the information and make sure that the weight and gravity of the offense matches the position that you're hiring for. So just because somebody has a record doesn't mean that you shouldn't hire them. Well, Pepsi was doing quite the opposite. They got dinged for $3.1 million and has since significantly changed their hiring and screening practices. Same thing with Madison Square Garden. This is a case from 2007. Employers have a right to use criminal background checks to screen applicants as long as the charge is related directly to the job in question. With this complaint, they asserted that the arena's withdrawal for employment offer violated Title VII of the Civil Rights Act. Now, this happened before the 2012 criminal records guidance, and what happened with the criminal records guidance was the way that the U.S. government works when there's with agencies like the EEOC is they're not a lawmaking authority. They don't have to go to an act of Congress to create rules. What they do is whoever's in the White House, which today is a Democrat, the commissioners are balanced toward Democrats. So there's 5 commissioners to the EEOC. There's 3 Democrats and there's 2 Republicans. So obviously any vote they're going to have, they're going to sway that way. Well, back in 2011, there was a lot. You guys probably remember this, there were a lot of negative stories in the press about employers using credit reports against employees. And a lot of states started passing, and cities started passing laws saying you couldn't use credit reports. Well, they were really aggressive. They really wanted to release information, or they really wanted to release rules and new guidance about the credit reports. Well, the head commissioner was getting set to retire, and they just didn't feel that that guidance that they had drawn up was ready for prime time, so they dropped it. But what they did have ready was their criminal record guidance. So in their infinite wisdom, without speaking to or getting counsel from HR professionals, they just went ahead and released this guidance. And we're going to talk about the guidance later. But the guidance, in a nutshell, is the weight and gravity of the offense must match the qualifications for the job. So if you have somebody that has a DUI but they're not driving, why are you using that against them? It gets a lot more in depth than that. The EEOC was created to curb discrimination in the workplace, which unfortunately still happens today. You know, we see it all the time when we open the paper, we see lawsuits, legitimate lawsuits the EEOC brings against people. Well, this guidance was brought because historically, minorities have a higher rate of criminal records than non-minorities. Therefore, if you use criminal records against somebody, you're discriminating against minorities. So that's the whole theory behind it. But they went a little bit too far with their guidance, and we have to talk about that. So there's 4 things that we're going to focus on today when we're talking about compliance and we're talking about the criminal aspect of the background check. How to determine whether you should hire a candidate with a criminal record, how to comply with the EEOC guidance, and something called the green factors in the individualized assessments, the best way to execute the adverse action letter process, and how to handle disputes. So, you know, there's a hodgepodge out there of things that we think about every single day as screeners and as HR professionals. Negligent hiring. Negligent hiring is the reason, really the reason why background screening companies exist. Back in the mid-90s, employers were getting sued daily for hiring people they shouldn't have hired. Somebody acted out violently. Workplace violence was really big in the mid-90s. When those things started coming to the surface in the media, employers said, well, to protect ourselves, we're going to do background checks so we can make sure that we're protecting our clients and our employees and everybody else. The theory of the negligent hiring lawsuit is if you could have known, you should have known. And a lot of people weren't doing proper background checks and they didn't know what they're getting themselves into. Things like job related discrimination, severity of the crime, job relation, age of the crime. These are all things that we have to think about when criminal records come to the surface and we kind of background check. So, who in here uses a hiring matrix when they are doing a background check or doing the background check results? I mean, we do. Most people do, right? Who in here sends that matrix to their background screening company to adjudicate the results on their behalf? Okay. Fewer than I would think. It's actually something that we're seeing a lot more of. If you read white papers that we wrote in the mid-2000s, we railed against background screening companies adjudicating on behalf of their clients. But now, in the last couple of years, we've really seen that's something that employers really want their screening companies to do. So what does that mean? It means that you develop on your own, without your screening company, with your legal counsel, all the things and all the crimes that you want to disqualify from employment of your company for different positions. Meaning, you know, it's a green if they have a DUI, it's a yellow meaning, you know, review. If they have maybe a theft and it's a couple of years old, and it's a red if there's Jared Fogel's going to work for you. So, you know, that's what a hiring matrix is. And when you're developing these matrices, you really want to do that independently of your screening company, because if you have your screening company help you with it, there's co-employment issues, there's issues that they can be dragged into in the legal process that you really want to avoid. So it's something you really want to steer clear of, and you want to work on closely with your legal counsel. But you really want to make sure when you're developing that matrix, you know, how is it going to work and how are you going to operate it? Whether you're using a screening company to adjudicate or not. Do you have centralized hiring? Is your hiring spread throughout the country? Do your HR professionals make their own decisions based on some matrix, or is it one master matrix? These are all the questions you want to ask yourselves, even when you're deciding whether or not you want to develop a matrix. But it's a good way to be consistent with your hiring practices and not showing discrimination by being consistent with who you hire and who you don't hire for the different crimes. Make sense? Any questions on matrices? Okay. So another question that companies have when you're using matrices is, do you want to have an equal balance between reds, yellows, and greens? Well, in our opinion, and in our legal counsel's opinion, and when we consult with companies about whether or not they want to do this, is really the fewer reds you can have, the better. Reds are a red flag for the EEOC to come in and say you're discriminating. Yellows are really where you want to balance any criminal records against. You want to have as many yellows as possible, as many greens as possible, obviously, because nobody's going to get in trouble for hiring somebody. You want to have as many yellows as possible in your matrix because we really want you to look at the reports. We want you to look at the weight and gravity of the offense. We want you to look at how old it is. We want you to make sure that your HR professionals are, even kicking that up the flagpole if they're unsure. After doing that, you're going to create something called, it's in the later slide, so we'll get back to that. Sorry about that. This is the part where I skip around and confuse everybody. Let's get into something else. I've ranted about that already. Let's talk about contractors. Who in here uses third-party contractors in their company? Lots of you. Okay, now I've got a couple of clients in here. I know that they do quite a bit. With contractors, you are just as liable as an employer by having them as an employee or a third-party contractor or PO or whatever else you have them registered as. So if they're walking into your company and they have your company's badge on, as far as the media is concerned, everybody else is concerned, they're your employee. So you want to make sure that your contractors, if you do use third-party contractors, are developing a very close matrix to what you're developing, and you can even share that with your contractors to make sure that if they're walking in your building, they're subject to the same guidelines as your regular employees are. Really, really important. It's something that a lot of employers overlook. We've got clients that have had, contractors that they want to hire on full time that we found significant records on. And they're surprised because they told their contractor to make sure they do a background check. But what does that mean? A background check can mean anything. Background check can mean me calling you and saying, hey, is this guy okay? And you say yes, and I say, hey, I did a background check. Even if you say, use a background check through any PBS background screening company, which is our national association, is it still equal to what your screening company is doing? Even if you say, my contractor is required to use an accredited company, everybody has different methods. You want to make sure you're very, very consistent in your practices with your contractors. It's really something we're seeing a lot of lawsuits about right now, and we're seeing a lot of liability with our clients. Okay. So there's two big cases right now. I feel like Marco Rubio. There's two big cases under the water.
We're actually a contractor that we're the subcontractor. So when we go on to, there's a couple places that we do work, they require us to do background checks, but they approve them and send them back to us. And we have one that's pretty prominent, but they're like all over the board. We have no idea how they're actually deciding who goes on and who doesn't go on their project.
Your client?
Yes.
Right.
So what is our liability in that? And they're turning away people that were like, they've been on federal projects, I'm not really sure why they can't go on your site.
Right, so, that's the employer's decision. The liability is really on them. So they're going to have certain standards. They might have a federal law that governs what can and can't work for their company. There's certain federal laws that say you can and can't do certain things. So that might be the reason, or it could just be the general liability of what they've decided that they do or do not want in the workplace. Generally, there shouldn't be much liability on you because you're not making the employment decision. If that makes sense.
Okay.
So there's two really big lawsuits right now that we're watching very, very closely. One of them is BMW, and I think I have a slide for that later on. The other one, is Dollar General. And they both have pretty egregious accusations against them. The Dollar General Complaint Commission focuses on a hiring matrix designed by the defendant with its background screen provider that identifies specific felonies and misdemeanors that will disqualify the candidate. The EEOC claims the Dollar General's matrix violates the guidance because it's not job-related and consistent with business necessity. What does that mean? Same thing that I said with the DUIs before. You have to make sure that the crime that you're using against somebody fits within the job relatedness and business necessity of that position. When the guidance first came out, screening companies were very concerned that there was going to be some language in there that was in there, it got stricken out, that you had to use an ISO certified psychologist to create something called a, I don't know what it's called. It's a report that they would have to deliver to you that says, for this position in your company, these are all the crimes that should disqualify the person from employment. Each one of these reports was guesstimated to be around $80,000. So for a company like a large employer that has 700 or 800 different positions in their company, it's obviously quite cost prohibitive. That was stricken out of there, but they still want you to do a job relatedness study. They want you to have some sort of documents that say, here's the positions and here's the things that we're really, really concerned about for these positions. You need to be able to prove that in court. Okay? So let's talk a little bit about the actual guidance itself. Like I said, it came out in 2012 in March, and when the EEOC creates their guidance, it's not law, okay? It's guidance. But what does that mean? When you break the law, something happens. You go to court, there's a whole process for it. When you violate their infinite guidance, it's the same thing, they sue you. The EEOC had 99,000 actions against employers in the last couple of years, every year for the last couple of years. They look to increase that every single year. Just having a reputation as a company that's unfavorable to the EEOC guidance will warrant an investigation. They're very easy to win, but they're expensive. So, is there everybody here been involved in the EEOC lawsuit? I've seen tons of them. And the EEOC itself has been slapped back down many, many times for bringing crazy lawsuits against employers. There was an employer in Michigan, it was a staffing company, and the EEOC alleged that they didn't hire 300 people because of the background check they were using against them. All along the lawsuit, the employer was like, no, we hired half the people you're saying we didn't hire. EEOC didn't listen. EEOC lost the lawsuit. They appealed the lawsuit, they lost again. And the federal judge in that circuit court basically made the EEOC recover $750,000 back to the employer of legal fees. I met with the EEOC the next year. We do a lot of lobbying for our association, and I was talking to somebody on the friendly side of the guidance, and I said, you know, is this people market lawsuit going to temper what's going on? You know, are they going to start being a little bit more judicious in their investigations? And they said, no, poke the bear. They're pissed, and they're going to do more of them. And we've seen this time and time again. We've seen a lot of lawsuits they've lost, and they're just relentless with it. So you got to be really, really careful. So with the guidance, we have a couple of different things we want to make sure that our clients and you guys follow. The first thing is, and we're going to talk about this in a minute, is the individualized assessment. Okay, I'm going to get back to that. But the three main features of the guidance are what they call the green factors. And green is part of a lawsuit. There's a person named Green. The green factors are, you want to look at the nature and the gravity of the offense, the time that has passed since the offense, and the nature of the job sought or held. And those are the three main things you want to look at every time you're seeing a criminal record come back on a report. They also want to make sure that it is job related and consistent with the business necessity, the JRBN, job related and consistent with business necessity, also very important. So the best practices that they want you to follow are, number one, and these are best practices, this is not part of the guidance, but it's in their guidance, this is the best practice, is ban the box. Everybody's heard of ban the box. Our in-house counsel and our chief compliance officer hates when I say this, but I don't hate ban the box. I really don't. I don't love it because it's hard to apply consistently across the country, and I do think there's a place to have the box. But it's not the worst thing in the world to actually interview an applicant and look at them and decide if you want to bring them to the next level because of their qualifications. It doesn't mean, and does anybody not know what ban the box is? Sorry, I won't go too far. Okay, so ban, for those who don't know, or afraid to raise your hand. Ban the box is the ability to ask an applicant on the job application if they've ever been convicted of a felony or misdemeanor in the last 7 years. So that basically, there's a lot of states that have passed laws that say you can't do it. The federal government has not weighed in and passed their own law, but they put it into the best practices of the guidance. So it doesn't say that you can't ask that question at some point during the hiring process. So what we recommend for our clients are ask it when you're actually having the applicant fill out the background check release. So they've already gone through a couple of interviews, you've decided they're qualified for the job, and you want them to fill out the background check release. Now it's time to ask them, have you ever been convicted of a felony or misdemeanor in the last couple of years, 7 years, whatever you want to put on there. We've seen a lot of our clients be very successful with that process and still being able to capture that important information before the background check is run. Okay? The second thing is developing narrowly tailored written policy and procedure for screening your applicants. One of the biggest things that we see in lawsuits and clients, or generally HR public losing lawsuits, is not having good policies and procedures. I do a lot of expert witness work on 5 or 6 cases right now. It's the first thing I ask the attorney, what were their policies and procedures? If they don't have good policies and procedures in place, they're probably going to lose a lawsuit. If they don't have good policies and procedures in place at all, they could be subject to a class action lawsuit because not only did it apply to one person, it could have applied to a whole class of people. If you do have policies and procedures in place, and you're pretty sure that they're being followed, and occasionally one of your recruiters doesn't follow them, it's actually better for you because you're not subject to a class action lawsuit. You could be subject to it, but you could easily win it because you actually have these written policies and procedures. So just not having the policies and procedures can really put you guys at risk. Determining specific offenses that may demonstrate unfitness for performing such jobs, the duration of the exclusions for criminal conduct. So let's say the person has a theft, but it was 10 years ago. And in the last 10 years, they've worked at 3 different places. They've gotten great feedback. They've got great reference interviews with their past employers. Everything seems kosher. You want to make sure that you're applying the length of time that happened and anything else that might have happened since then to your decision. Record the justification for the policy and procedures and exclusions, including a record of consultations and research considered in crafting the policies and procedures. That's a mouthful. So you created your policies and procedures, but how? Did you just throw a dart at a dartboard and say, well, this crime works, this crime doesn't? You want to make sure that if you've had discussions with anybody, your legal counsel or anybody else who developed these policies and procedures, that you've recorded that somewhere that you can go back to and make sure that you can justify that again in a lawsuit. Training your managers and hiring officials and decision makers on how to implement the policies and procedures consistent with Title VII. Really, really important. I have policies and procedures, but I don't even know where they are. I don't even know where to look for them. You want to make sure that not only do you have them, but you're training your recruiters and your other professionals in your company on these policies and procedures. Not only are you training them on them, you're doing it often, maybe every quarter. Not only are you training them every quarter, but you're recording who's in every single meeting, so you're taking attendance to make sure that you're covered on all ends. That if you do get sued, that you can actually produce these documentation. So those are the best practices. Any questions on the best practices?
My understanding was that once you got past the application, the interview process, you could ask that question. You're suggesting not to ask it until later in the interview process?
Yeah, I mean, you could ask it after the application. We suggest you take the can a little bit further down the road. You could ask it in the interview, maybe the second interview. You just gotta be careful because there's some states and some cities, some local jurisdictions that have their own laws about man the box. When I've talked to employers, I've said, let's look at the most conservative law out there. I think Seattle's got a pretty conservative one. And if you hire in all these different cities, let's be consistent with the most conservative one out there. You probably could get away, and this is something I want to talk to your counsel about, you could probably get away with doing what you just suggested, but do you need to? And that's what I would ask myself. Where does that fit into the process? Okay? Sure.
Back to the matrix being a devil's advocate. If EEOC is looking at your matrix, then you've got something in black and white, which can be good, can be bad. As opposed to not having a matrix, looking at every candidate individually, making a decision consistently. Is that, you see more liability there than in matrix?
On both. And can everybody hear the question? You know, liability of having a matrix versus not having a matrix. It depends, which is the most unclear answer you can give. It's one of the reasons why I suggest always using lots of greens and lots and lots of yellows. The more yellows you have, it shows that you're using your brain to make that decision. Red should be very, very egregious. A sex offender working in a school. Jared Fogle applying for a job at your company. I just found out last night he's actually from Indianapolis. I had no idea. So I'm sorry that it's so close to home. But you guys have a great football team, and I'm from Cleveland. So yeah, you really want to be careful when you're crafting that matrix to make sure that that crime, that red, is so clear that that person shouldn't be hired. The problem with not using the matrix is you could be inconsistent in your hiring practices, meaning one of your plants in Ohio hired a white person with a theft that was 2 years old, but didn't hire a Latino in Indiana that had a theft that was 2 years old. Then you could be, claimed for discrimination. So I think the matrix, personally, I'm not a lawyer, I just play one on TV and I probably have a degree somewhere that says that I am. You want to make sure that you're applying. Make sense?
Where I work, we have different licensing bodies who dictate who we can hire based on their background. Are the most stringent licensing body dictates no felonies at all, regardless of what the felony is. So that is the practice we follow in all of our programs, even though it may not necessarily apply to the job that we're working in.
I'm so glad you asked that question. It's such an important question. What she asked was, if you didn't hear her, is there certain licensing bodies that say you can or can't hire certain people for certain reasons? Well, the EEOC in their infinite wisdom said, if there's a federal law that states you can or can't hire somebody, there's a safe harbor for that, right? So if the federal licensing body says you can't hire somebody with a theft, anything with theft or dishonesty in the last 7 years, you're safe, we're not coming after you. Wait. If there's a state law that says you can or can't hire somebody for some certain reason, they're coming after you. There is no safe harbor as an employer for following a state law. So there's an old Latin term, and if you guys heard about, some of you heard my presentation yesterday, in law school, called you're damned if you do and damned if you don't. So the licensing body in that state's going to come after you, but the EEOC won't. Basically what happens. So that's one of those things you want to discuss with your attorneys. We were hoping to get clarification from the EEOC on that very topic, and it's clear as mud. But if that licensing authority is at the federal level, you're pretty safe. So that should make you sleep at night, right? So practical implications for employers. And these are the things you really want to pay attention to. And again, don't worry about taking notes. If you leave in your car, I'll send this all to you. There's really good information. We did a white paper right after the EEOC guidance came out that we'll send you. It's got all this information in there. But the practical implications for employers are eliminate policies that exclude applicants with any criminal record. The whole reason that the EEOC guidance came to be is they started getting complaints, a lot of complaints, that there were actual job listings out there, and there's some on Craigslist that they produced during this whole process, that said, hey, come apply for our job, criminals need not apply. Really, employers were doing that. If you have a criminal record, don't even bother applying. That's what kind of raised this whole process to the surface with the EEOC. So you want to make sure that you eliminate any policies that exclude records for any single reason. You want to review your paper job applications and pre-hire documents. If you're using an applicant tracking system or web-based applicant entry system, consider removing any inquiries about criminal record history from the application. And I've heard this time and time again, who uses an applicant tracking system here? Most of us now, right? I've heard employers say to me, oh, if we have to ban the box, our ATS will just move it off there for us. I'm sure it's already done. That's not what your applicant tracking system is there to do. They're not there to interpret law for you. If you want to move something off your application, you need to call your applicant tracking system and say, we no longer want this on our application. Don't expect them to do it for you. Don't expect your background screening company to do it for you. I mean, us background screeners are out there railing against stuff like this and talking about stuff like this and speaking about stuff like this. But we're not there to make legal decisions for you and remove things off your application. A lot of us today use candidate self-service portal. So when you go to run a background check, instead of having to fill out all the information on the website, you just fill out their name and their date of birth and their email address. It sends an email to the applicant and they fill out the rest of the information. You know, we're not going to make changes to those forms because we saw some law that says we should do it. That has to come from you. You have to do that and initiate that. So don't expect somebody else to do it for you. You want to make sure that you review all that stuff on your own behalf and then go to your vendors and make sure that those changes are made. Limit inquiries about criminal convictions to those that are job related. So if you have a position that you're hiring for, then it doesn't matter what they have, you still hire them. Remove that off the entire process. Who cares? You don't need it on there. It's just going to get you in trouble. While individualized assessments are not required by Title VII, the guidance implies that without it, you have a more difficult defense. No examples are given of a scenario where an employer is successful without individualized assessments. And we're going to talk about individualized assessments next, so I'll get into that in a second. If an individual does not respond to requests for additional information under the individualized assessment, they're not clear as to how long you should wait. Again, we'll get into that in a second. If you use a third-party CRA to conduct criminal screenings, review your packages and the reporting policies to ensure compliance. What does that mean? Some of our clients say, I only want to see felonies, or don't give me anything that's more than a class 4 misdemeanor. All those different things that you have in your packages or services that you're ordering, you need to make sure that you review those with your screening company on a pretty regular basis. A good example of that is some of the states a couple of years ago that outlawed credit reports for employment decisions unless it was for certain types of positions. Well, employers just thought, oh, my screening company knows about these laws, so they're just going to remove that from my package. Again, no. That's something you need to review with your screening company on a regular basis. If you're not reviewing your packages at least once a year, you need to, basically. I know with our larger clients, we try to meet with them at least 4 times a year. Part of that process is we look at their packages and make sure that they don't have any liability with some of the services that they're ordering. If you use a third-party CRA, the CRA is a background screening company, to adjudicate criminal results, consider building in a review process to comply with individualized assessment recommendations. Consider the FCRA adverse action letter process. We're going to talk about that in a second as well. And the biggest thing that you can take away is simply having that reputation simply having the reputation for discouraging applicants based on race may invite an investigation by the EEOC. Large applicant pools have a greater potential for disparate impact, meaning if you're a larger employer, you're the ones the EEOC wants to go after. They don't want to go after Joe's Garage, okay? They want to go after the biggest companies out there because they want to make headlines. The EEOC, when they win these cases, they want to win them against big companies. Disney, Dollar General, BMW, those make headlines. Okay, small employers don't. So you're the ones who, just by having a tiny reputation out there of being unfavorable to somebody's criminal record, that's going to warrant the action. And honestly, applicants right now are educated in this stuff, and so are lawyers. So every time you deny somebody a job based on their criminal record, they could make a phone call to the EEOC. Even if you're 100% right, it could warrant an investigation. So everything that we're talking about today, everything that you have in place will just help you win these lawsuits. There's a couple more practical implications, but I'm going to send those out to you by email. I really want to get into the individualized assessments. So what individualized assessments are, is it's your turn, once the criminal record comes back, to have a conversation with the applicant. And this conversation can happen in a bunch of different ways. It can be by email, it can be sending them a letter, or it can be making a phone call to the applicant. And what that means is, what's your name? Okay, good idea. Your purple shirt. Yeah. Marshall. Marshall, I'm your employer, or I'm your potential employer. I'm going to give you a phone call and say, hey, Marshall, I found on your application, I'm not going to embarrass you. Sometimes they say things like solicitation and stuff, but I won't do that. Marshall, we got your background check report back, and we found on here disorderly conduct from 4 years ago. Would you tell me a little bit more about what happened? Marshall's like, listen, I was drunk, I was in college, repeated a stop sign. I got to tell you, happens all the time. And the reason I use disorderly conduct is because it could mean a lot of different things. It could mean you were drunk in college and you repeated a stop sign. It could also mean that we're in a movie theater right now and Marshall stood up and yelled fire. and everybody ran out. So it can mean a lot. It can also mean terroristic threats. I mean, it can mean a lot of different things. So you want to make sure that Marshall has an opportunity to go back to his employer and say, here's what happened. And here's proof of what happened. I'll show you the ticket, and I'll show you the complaint. This is all that happened. Or, listen, I wrote a check to somebody, and my wife didn't tell me that she wrote another check, and it bounced, so I got a theft by check on me. Here's the complaint. It's your opportunity to go back to your employer and show exactly what happened with that record. Now, when they applied these individualized assessments and put this into the process, what they didn't do is they didn't say, here's how you should do it, and here's how long you should wait to hear back from the applicant. Here's the methodology behind it. They didn't do any of that. They just said do it. So finding a process that works well for your company is the best thing that you can do. Here's where we've been successful. We've found that a lot of our clients have been very successful in just including a letter with their pre-adverse action letter. So pre-adverse action letter, we'll get into in a minute, is part of the FTC or FCRA. If you include that individualized assessment letter with that, that pretty much complies. If you have a conversation with the applicant over the phone and I say, Marshall, I found this on your record, and you explain it to me, that also complies. But the one thing you need to do when you're doing that is what? Document it. Or of course doing it by email. So there's a lot of success in doing it in that way. Once you do it, and once you've documented it, it's done. You can pretty much move forward with it.
So, for Marshall, would you actually ask them to send you the information to actually prove that that's all it was? Or do you take their word for it and break down that?
Well, you never take anybody's word for anything. And if I do ask Marshall what happened, and he tells me, even if he provides me with a complaint, you need to take that information back to your screening company and say, pull this file. I want to see exactly what happened. I mean, I can tell you how many times an employer has said, well, this is what the applicant just showed me. We're going to hire them. We put the brakes on that. I've got a great war story. This is where I go off on tangents here. I'll try to save this one for later. I'll tell you now. We won a big account about 10 years ago. Huge advertising and PR conglomerate, one of the biggest in the world. And any time that a screening company or any vendor takes over an account from the corporate level and it trickles down to all the different subsidiaries, there's always resistance because you might love your ATS or your screening company, you have a great relationship, and now somebody's telling you to use somebody else. Well, one of these agencies had spent 6 months recruiting somebody, and we did a background check on them, and they said that they received their degree from while they were in the military and stationed in Iceland. The University of Maryland had a program where they were able to receive the degree through the University of Keflavik, Iceland. And they produced a diploma, and we had a copy of it, and we called and we did the background check. The person was pretty much clean except that diploma we couldn't verify. We called Keflavik, we called University of Maryland, we called the U.S. Records Depot in Germany. Could not find any record of this person ever attending that school. Well, this person, her name was Donna, called us and said, you guys are the biggest morons I've ever met in my life. I can't believe that our corporate office made us switch to you guys. You're clowns. I'm calling the corporate office and telling them to fire you guys immediately. I worked for 6 months on this recruit. Now you're telling me I can't hire them. You're a bunch of clowns. So we kicked it up. We had 4 more people in the office work on this search. Same result. Okay? Now we're getting calls from the corporate office saying, we chose you guys, we went through an RFP, now you're making us look ridiculous in front of all of our subsidiaries. So I said, all right, this makes no sense. So I put my investigator's hat on. I retraced every step that we had. I looked at every person that we called. We record everybody's name, phone number that we talked to, everything else. I retraced every step along the way. And I found the same thing that they found. I was getting on a plane from Savannah, Georgia, back to Cleveland. I was visiting another client, and our head of client relations called me at the time and said, I just got an email from the client, from the registrar's office, saying that the person did in fact graduate, and the client is pulling our contract with us. And I said, there's no way. There's no possible way. I said, my plane's taking off in 15 minutes. I said, send me, I had a BlackBerry, I had one of the little BlackBerries. I said, send me the document, I want to look at it. And I looked at the email, and I said, I want you to go, I called her back, and I said, I want you to go online to the Who Is directory. The Who Is directory is when you register a website, everything is registered through Who Is, and you can see who registered the website. What this person did is they created their own website for kevlevec.edu, but they just transposed, who knows how to spell Kevlevec? I don't. They transposed 2 of the letters and created their own website, their own email address, and emailed themselves the information. And I mean, I jumped up out of my seat, hit my head on the thing. I was so excited that we found this. Well, now this Donna, who worked for the subsidiary, she's been with 4 other companies since then, and she sings our praises everywhere she goes. Everywhere. Because that's how, people are desperate. They want to work. And once you get caught in a little lie, a lie begets a lie begets a lie. You just can't get yourself out of it. Well, this happens. I mean, over 50% of the applicants that we screen have something wrong, or something that we found as a discrepancy in their resume. So there's half the people have it. So you got to make sure that you re-verify them. It's a long answer to your question. You got to make sure that you re-verify the information with a third party and not just take the word on it. So, any other 25-minute responses I can make to questions? So that's the individualized assessment. And again, I think it's a very easy process. It's a very friendly process. I think it's good for the applicants. I think it's good for the EOC. I think it's good for minorities that might feel discriminated against. It really gives somebody a chance to justify the record that they might have had in the past. And again, everybody makes mistakes in life. Everybody deserves to get a job. And it's just making sure that the right person is in the right place in the company. So again, we have already gone through this. This is how you apply this in the real world. Again, you can do it any way you really want to do it as long as you document it. So this is the BMW lawsuit, which we've already really kind of gone over that. So who in here knows what the adverse letter and the pre-adverse action, the adverse and pre-adverse action process is? Okay. I'm hoping that I get 100% participation with these hand raises because the adverse action letter process has been in place for 20 plus years. Okay. This is an EEO, this is a FTC and CFPB regulation. It's under the Fair Credit Reporting Act. Does anybody not know what the Fair Credit Reporting Act is? I sleep with a copy under my pillow. It's a law, the federal law that governs everything that we do with the background screening process as an employer. Back in the 90s, in the early 90s, people thought, hey, it's public record, I can use it. I don't even need to have them sign a release. Like, it's public record, I can do whatever I want as an employer. It's true, these things are public record when you're looking at criminal records, of course. But once you apply it in an employment decision, the FCRA comes into play. Now, there's a couple of loopholes there. The FCRA does not apply if you do background checks on your own. Okay, if you don't use a third party, technically, the FCRA does not apply. So what does that mean? Really no employers, I have not seen one in 10 plus years that does their own background checks. But let's say you don't do criminal background checks and you just do you just verify everything on the resume yourself. Okay? And that's the extent of your background check. I mean, the next conversation we're going to have is how dumb you are for not doing the regular background check. But, and I guarantee you nobody is doing just that. Technically, under that process, you don't need to follow the FCRA. But since everybody does use a third party nowadays, the FCRA applies no matter what. So once you get anything negative back on a background check report, and that could be anything, that could be something in discrepancy in their education verification, that could be something in the credit report, it could be something on the criminal record. Any red flag that comes up that you say, I'm not going to hire this person because of this record, EEOC stuff aside, okay, you need to follow this process. And what that means is, you then send them a letter in the mail or by email, you can't do it by email, that says, hey Marshall, we just found this on your record, and we think it's you, and this is your opportunity to dispute this information. So here's the number of the screening company, here's my number. If you feel this isn't you or this isn't accurate, in the next 5 days, please give us a call. If we don't hear from Marshall, and I'm also going to include, this is very, very important, with that you need to include a copy of the report, a full copy of the report, and something called a summary of your rights under the Fair Credit Reporting Act, which is a document that your screening company should be providing to you. All that information needs to go out to Marshall. He needs to look at that and decide whether or not he wants to dispute that or question that information. As an employer, in the next 5 to 10 business days, 5 business days is the general rule. If you don't hear hear back from them, then you go ahead and send them something called an adverse action letter. Marshall, sorry to make any Marshall, by the way. We are not going to hire you because of this information. This isn't part of the law, but it's a best practice. I include again another copy of the summary of their rights. Okay, very important. What we're seeing today with plaintiffs' counsels are very technical violations of the FCRA is warranting lots and lots and lots of class action lawsuits against employers. If in that first letter you forget to put a summary of their rights, okay, or you wait too long to send that letter out, that's a technical violation of the FCRA. We're seeing multi-million-dollar lawsuits won by plaintiffs' counsels for these technical violations. We've seen cases where they send the information out, it doesn't include the report. We're seeing that the release isn't, they're not using a proper release when they're having the applicant sign up for the background check. We're seeing tons of these. Okay, again, I'm an expert witness, and I'm called probably once a week by some counsel out there to represent, or they need an expert on the process that they follow. And we're seeing lots of technical violations as well. So make sure that you're following this process exactly. I've got an ex-client who we recently fired, and we had a meeting with them, and they said, put his arms back behind his head, and he goes, yeah, we don't send these letters out. He goes, we just find some other reason to say that we didn't hire a person. And I said, okay, well, you think you're smarter than the FTC, and you think they've never heard that before? And he said, our counsel told us that's cool. And I said, you're going to get sued and you're going to get us sued. See you later. So, having that, in the late 90s and early 2000s when background screening became bigger and bigger, we saw a lot of employers trying to get away with that. You're not going to get away with that anymore. You're just not. When the financial crisis happened in 2008, President Obama at the time created something called the Consumer Financial Protection Bureau. And that was to protect consumers against lending and all kinds of different stuff that we were seeing out there. Well, what happened was they rolled the enforcement of the FCRA into the CFPB. So now, as screening companies, as employers, we have two government bodies overseeing one law. So we got the FTC that's charged with creating the rules and creating the definitions and everything else of the FCRA, but the CFPB is enforcing it. And if you think those two agencies ever talk to each other, they don't. So there's all kinds of haphazard things happening with the FCRA nowadays. So you got to make sure you're following this along, this process. Any questions on the adverse action letters? Okay. Mickey Mouse is in trouble. The company known for their signature character Mickey Mouse is defending class action claims based on questions about its background screening process. The suit against Disney was filed in 2013, and the complaint alleges that Disney's policy for notifying applicants about background checks has violated the FCRA. This lawsuit is still pending, but this is exactly what we were just talking about. They were not properly sending out pre-adverse action letters. Again, how you apply this in the real world, these can go out by electronically, they can go out by email, they can go out by regular mail. What a lot of employers have started doing, and I highly, highly recommend this. I'm not trying to sell you our services. Use your own screening company. Use your screening company to send these letters out. Why? That's your process. That's your written documented process. You're relying on a third party to do it for you, therefore you're expecting it gets done. Okay? If you're a smaller employer and you don't have the bandwidth to get these things done, you wait a couple of days, that could lend yourself to a lawsuit. If you're using a third party, again, that's your policy and procedure. That's in place. The responsibility is on them. So I highly, highly, highly recommend that the letters go out by a third party. Okay? So the dispute process. This is one of those slides that I wanted to include in here because it's important. So a lot of times, I hate to say this, but background screening companies can be wrong. Not wrong because we did the work wrong because the information we got was wrong. For instance, an expungement wasn't filed properly. If you're in California, there's really no such thing as an expungement. There's 1102.3, I think it's called. It's a document that gets filed in front of the file that says this record doesn't really exist, but it's still there. a lot of times these forms get filed incorrectly in the file, and the record's still produced to us, we still report it, and then we have to go back, and the applicant disputes it and says it was actually expunged, they produced the form, we verify the form, and they were correct. We could have gotten bad information from an employer. You know, they told us there was a salary discrepancy, but they didn't include a bonus. We went to a court and pulled a felony, but the court didn't properly put in the pleading that it was pled out on misdemeanor. So we see these things a lot. And a lot of times, you know, when an applicant is getting their background check report back, it's the first time they're even seeing something. Is anybody hired in Texas or Florida? I think like 99% of the population of those two states have theft by checks. Because there's a state law that says if you bounce a check for $1.12 at Walmart, Walmart's required to turn that check into the county court and they issue something called theft by check money. Most people don't even know they have it. They find out about it, they pay a $25 fee, and they pay Walmart $1.12, and it's off the record forever. But it's the first time they're hearing about it. So when somebody gets that report back in the mail, it's their opportunity to see it for the first time to clear it up. It's very important that your screening company treats these people with respect. A high level of respect. Not only a high level of respect, but they should be treating them like they're an arm of your company. Because this is your brand. These are your future customers, hopefully your future employees. You want to make sure that they go into this process feeling good about it. The background screening process is the scariest part of the hiring process for anybody. Even if you know that you're completely clean, it's scary. It's like getting a drug test. Even though you know you've never done a drug in your life, you just never know what somebody's going to find in some lab somewhere. It's scary. So you want to make sure that the process that your screening company is following treats these individuals like you would treat them as their employer. Okay? What does that mean? Well, the screening companies have like 30 days to clear up these discrepancies. And sometimes they do take 30 days. I mean, sometimes the record could be sitting in a warehouse somewhere and we have to order it from the clerk. But you want to make sure that your screening company is jumping on these immediately, because this is somebody that's waiting to get a job, waiting to get a paycheck. And you want to make sure that they're treated with that respect. So, you know, generally, if it's a very easy thing to clear up, it should just take a couple of days, and you should be keeping that position open for that person. Under the pre-application process, they have that 5 days, that position should still be open to them during that 5 days. And if they prove the fact that the record didn't exist or it was incorrect, you should be able to hire that person in turn. So what do you do when an applicant tells you that the report is wrong? The first call that you should make is to the screening company. And the first thing you should tell the applicant to do is contact the screening company as well. You should be out of that process. That's not your job. You're an HR professional. The screening company produced the report. That's their responsibility to actually go through it and follow that dispute. How long do you need to wait for the applicant to clear the report? Again, you need to wait under the pre-adverse action letter process about 5 days before you send out the adverse action letter. Can you fill the position? Technically, yeah, but you better have another position they're waiting for them, the same position waiting. So if you got 5 openings for that position, you want to make sure that you fill one of them with that person. So, any questions on that? Okay. Now we're going to get into one of my favorite things, and that's statistics. So, everybody in here, is anybody that does do background checks today? Salt anybody in this process? No. Everybody does background checks nowadays. I mean, it's very, very rare that we do a presentation or that we talk to a company that says, yeah, background checks, never heard of them. Or, yeah, background checks, why should I do that? We just don't have those conversations anymore. What we do have are conversations about your background screening process and why it's not very good. So every day, you know, we'll talk to employers and they say, well, you know, we really can't afford to do an extensive background check, so we do current county only. Or we just do a national criminal database. Well, if you've been on our webinars or read our white papers, you'll see that that's just not good enough. We do a lot of statistical studies, we do a lot of analysis, we do a lot of decision-making based on metrics as a company. And with that information, we're able to produce good data for the HR professionals out there. The one thing that we found is you are only doing current county only on your applicants, you're missing 53% of the records that exist, because only 47% of the records that we find, and we do enough of them that we can say this is probably, you know, this goes for everybody in the country. that you're only finding 47% of the records. If you're doing first county and second county, you're only finding 47 to 25%. The third county finds 10% more records. The fourth and 10th counties find 12% of records. And not using something called a national criminal database, you're still leaving 6% of the records on the table. What does that mean? There's about 100 people in this room, okay? And we're a little sidetrack. I've met with the FTC, I've met with plaintiffs' counsels, and they're like, I'm so sick of hearing about sex offenders. Like, it never happens. Like, you guys use these wild excuses of sex offenders in the workplace, and we just know that that's so rare. It's not rare, okay? There's hundreds of thousands of sex offenders out there. Millions.